Tonight, we begin with a legislative development that immigration attorneys, lawmakers, and policy experts had anticipated, feared, and warned about for months. A sweeping immigration reform that unfolded not over years of debate, but in a single congressional session. A single session that rewrites the rules for millions of green card holders. A single session that introduces compliance requirements never before seen in U.S. immigration history. A single session that could cost you your permanent resident status if you're not prepared. What Congress did today crossed a line that immigration advocates had hoped would hold. And when that line broke, the immigrant community did not hesitate. They responded with urgency, organization, and determination. If you hold a green card, have family members with permanent residency, or are in the process of applying, everything you thought you knew about maintaining your status has just changed, and the clock is already ticking. For 18 months now, there had been signals, not official announcements, not formal legislation, just signals, that the Department of Homeland Security was preparing something unprecedented. Congress has been vocal about immigration reform, yes, but they have been methodical in their approach. Their moves have followed a certain pattern, a rhythm, almost a predictability. But what set off alarm bells in Washington and immigration law offices across the country this spring was that the pattern went silent. Immigration policy experts who monitor legislative activity know the indicators. The sudden closed-door committee meetings, the unusual bipartisan cooperation on enforcement measures, the drafting of extensive regulatory frameworks, the sudden silence from usually vocal advocacy groups. All of that went quiet. And whenever Congress goes quiet on immigration, it means something massive is about to get loud. For weeks, immigration attorneys reported receiving calls from anxious green card holders who had heard whispers about new requirements. Some dismissed these concerns as rumors, others took them seriously. Those who took them seriously were right, because what emerged from Capitol Hill this week wasn't just another policy tweak. It was a complete restructuring of what it means to hold a green card in America. Early Tuesday morning, the Senate Judiciary Committee released what they described as comprehensive permanent residency reform legislation, including provisions that had not been publicly discussed in over 3 decades. These are the kinds of requirements that lawmakers only introduce when they are signaling something very specific: a fundamental shift in immigration philosophy, a response to mounting political pressure, or a preparation for even stricter future enforcement. Immigration analysts didn't know which category this fell into, or whether it fell into all 3 at once. But what they did know was that the administration was changing its entire posture on permanent residency. And when government shifts policy without extensive public debate, even by small measures, every green card holder in America needs to pay attention. The legislation, now officially titled the Permanent Resident Accountability and Compliance Act of 2026, introduces requirements that will fundamentally change how green card holders live, work, and travel. Let me be clear about what this means. If you are one of the approximately 13.9 million lawful permanent residents in the United States, your life is about to get significantly more complicated. The advisory issued by the American Immigration Lawyers Association tonight was not normal. It was not routine. It was not symbolic. It was urgent. Attorney after attorney described Congress's move as unprecedented in scope, aggressive in enforcement mechanisms, and perhaps most importantly, retroactive in application, meaning current green card holders, not just future applicants, must comply. But legislation only works if affected individuals hesitate to prepare. The immigrant community did not. In fact, the response today was among the most organized and rapid we've seen in recent immigration history. Here's what we know. Within 48 hours of the bill's text being released, immigration law firms across the country reported a 300% increase in consultation requests. These weren't routine check-ins. These were emergency consultations, the kind of meetings that green card holders only schedule when they are preparing to protect everything they've built in this country. Community organizations activated phone trees, legal aid societies opened emergency hotlines, and millions of permanent residents began asking the same question: what do I need to do to keep my green card? Tonight, Congressional sources confirmed that the legislation introduces mandatory compliance requirements on all permanent residents, including those who received their green cards decades ago and had assumed their status was secure. The law requires action before green card holders can fully understand the implications. Let me break down exactly what this law contains. Requirement 1. Annual physical presence documentation. Green card holders must now document and report at least 183 days of physical presence in the United States annually. This isn't just about living here. This is about proving you live here, with documentation. Requirement 2. Biometric re-registration. Every permanent resident must complete biometric re-registration within 24 months of the law's implementation. This includes fingerprinting, facial recognition enrollment, and iris scanning at designated USCIS facilities. Requirement 3. Financial compliance verification. Green card holders must demonstrate continuous tax compliance and provide evidence of financial self-sufficiency. Those who have received certain public benefits may face enhanced scrutiny. Requirement 4. Address reporting within 10 days. The current requirement to report address changes within 10 days is now strictly enforced. Failure to comply will trigger automatic review of your permanent resident status. In other words, Congress targeted every aspect of permanent residency: the documentation that would prove continuous presence, the biometric data that would enable enhanced tracking, the financial records that would demonstrate self-sufficiency. This is what made the immigration community's response so urgent. Congress's move wasn't just symbolic, it was immediately actionable. It represented the kind of reform that could result in status revocation if left unaddressed. And green card holders, understanding that fully, must respond with preparation. Not panic, not delay, but strategic, informed action. They shouldn't ignore notification letters. They shouldn't assume their long-held status protects them. They must gather documentation. They must consult qualified immigration attorneys. And here's where the story becomes even more significant. Policy analysts now believe that Congress's latest move was designed to test the organizational capacity of immigrant communities after years of enforcement challenges. Lawmakers wanted to see whether green card holders would respond with confusion and inaction. But instead, the opposite happened. Immigration advocacy organizations didn't hesitate. They launched information campaigns that were so comprehensive, so coordinated, that even skeptical lawmakers noticed. You don't get Congress's attention easily when it comes to immigrant organizing. But this week, the community did. Immigration attorneys speaking with media under anonymity described Congress's approach as strategic pressure, a way to shift permanent residency from a path to citizenship into an ongoing compliance obligation. But green card holders are proving today that they remain both informed and mobilized. Their responses were not only rapid, they were organized so precisely that consultation scheduling systems across the country crashed from demand. That demand matters because it shows immigrant communities understand the stakes. It shows that green card holders are not passive observers of policy changes. They are active participants in protecting their status. As reports continued coming in throughout the week, we learned more about the scale of the legislation's requirements. USCIS will require complete re-registration of all 13.9 million permanent residents within 36 months, forcing the largest administrative undertaking in the agency's history. The IRS will cross-reference tax compliance data with immigration records in ways that have been restricted since the privacy reforms of the 1990s. State and local law enforcement operating under new cooperation agreements will reportedly have access to real-time status verification systems previously reserved for federal authorities. This wasn't just immigration enforcement expansion. This wasn't just bureaucratic procedure adjustment. This was systemic restructuring. This was a redefinition of permanent residency itself. And redefining permanent residency is the one thing immigrant communities have fought hardest to prevent since comprehensive reform attempts of the 2000s. For every path to citizenship proposal that has been introduced, enforcement-focused legislators have countered with something that added conditions and complications. This law is the culmination of those efforts. Remember, some lawmakers thought immigrant communities wouldn't organize in time. They thought green card holders felt too secure to mobilize. They thought the complexity of the legislation would prevent unified response. But this week, the exact opposite is happening. Immigrant communities are organizing faster than ever before. Legal resources are being deployed at unprecedented scale. Information is spreading through community networks with remarkable efficiency. Green card holders who haven't thought about their status in decades are suddenly consulting attorneys. Families are gathering documentation they never thought they'd need. And advocacy organizations are preparing for what they describe as the most consequential immigration fight of the decade. What makes this moment so critical and so complex is that Congress's latest move happened at a time when the administration is under enormous political pressure. Border security advocates want stricter enforcement. Business groups want stable workforces. Immigrant communities want pathway protections. Civil liberties organizations want due process guarantees. And lawmakers are balancing these demands while facing election year calculations. When legislators in that position make sudden, sweeping moves, they're not doing it from careful deliberation. They're doing it from pressure. They're doing it from political necessity. They're doing it from the recognition that immigration remains one of the most potent issues in American politics. And green card holders, millions of people who have built lives, raised families, started businesses, and contributed to communities across America, are caught in the middle. The Department of Homeland Security's statement, now circulating across all major news outlets, was designed to signal that the administration is committed to what they call ensuring the integrity of permanent residency. Officials said plainly that the current system was inconsistent with modern security and compliance standards. That is bureaucratic language for, we're fundamentally changing how green cards work, and current holders must adapt or face consequences. You don't usually hear that tone from immigration authorities unless something serious is at stake. The implementation timeline alone tells the story. Biometric re-registration begins in 6 months. Address reporting enforcement begins immediately. Physical presence documentation requirements begin with the next tax year. This is not a distant future concern. This is happening now. Meanwhile, the American Immigration Lawyers Association's president addressed members in a direct, sobering speech today. She said, "Every green card holder in America must take immediate steps to document their status compliance." She said, "Assumptions about grandfather clauses and long-term residency protections are no longer reliable." And she said, "If you haven't consulted with an immigration attorney in the past 5 years, that consultation is now urgent." These are not rhetorical flourishes. These are statements from a professional organization that understands just how high the stakes have become. Here's what makes the situation even more concerning. Congress's latest move wasn't isolated. Along with the primary legislation, the State Department also announced enhanced scrutiny for green card holders seeking to renew travel documents. USCIS implemented new fee structures that more than doubled application costs for several status-related filings. ICE increased staffing for status compliance investigations, targeting permanent residents who travel frequently. All of this happened within the same legislative session. When Congress moves multiple pieces at once, it means something larger is underway. This appears to be a coordinated effort to transform permanent residency from a stable status into an ongoing compliance obligation. Immigration analysts are now considering several possibilities. One is that Congress is preparing for comprehensive immigration reform that will require documented compliance as a prerequisite for citizenship applications. Another is that lawmakers are attempting to reduce the permanent resident population through administrative attrition. A third possibility, the one worrying attorneys the most, is that Congress is attempting to create a system where any minor compliance failure could trigger removal proceedings. But today, green card holders have the opportunity to take that risk off the table. They shouldn't wait for official notices. They shouldn't assume their situation is too stable to be affected. They shouldn't rely on assumptions about how the law has always worked. They should act now to ensure they meet every requirement before deadlines arrive. What we're watching now is a test of preparedness. Congress wants to see compliance rates that justify their policy approach. Green card holders need to demonstrate they can meet requirements without losing status. Immigration attorneys want to prevent mass status revocation, and advocacy organizations want to prevent this model from expanding further. The outcome depends entirely on what happens in the next several months. Tonight, we've heard from USCIS sources who are now developing implementation procedures. They say processing infrastructure will be strained beyond current capacity. They say biometric appointment availability will be severely limited in the first year. And they say Congress's decision to include retroactive requirements is likely part of a broader strategy intended to maximize compliance pressure. But green card holders are not powerless. In fact, green card holders who act early have significant advantages. Their response now, organized, informed, and proactive, sends a message to Congress that immigrant communities will adapt to new requirements. And it sends a message to immigration authorities that compliance cooperation, not enforcement confrontation, will characterize this transition. As the implementation period begins, we expect more details to emerge about exactly what Congress hoped to achieve. But what we do know is that the immigrant community's response has been timely. It has educated millions of green card holders about new requirements. It has mobilized legal resources across the country. And it has demonstrated that immigrant communities remain organized and resilient. What happens next will depend on what green card holders do in the next 6 months. If they comply proactively, this moment will be remembered as a challenging but manageable transition. If they delay or ignore requirements, immigration authorities have already shown they are prepared for aggressive enforcement. They have shown they are ready to act. And tonight, for the first time in decades, every green card holder in America appears to be reassessing their status. Immigration law offices are overwhelmed, phone lines are jammed, and when millions of permanent residents are scrambling, it means they are preparing. It means they are taking action. Because this week, green card holders learned something they may have forgotten. Permanent residency requires permanent vigilance. Documentation isn't optional, it's essential. And assumptions about secure status can be dangerously wrong. This story is far from over. But tonight, one thing is clear. The rules have changed, the deadlines are real, and preparation must begin immediately. And we will be here, watching every development, bringing you every update as this unprecedented immigration transition unfolds. Stay informed, stay prepared. And if you hold a green card, don't wait to take action. Subscribe and enable notifications to receive the latest updates on these developing immigration changes.